বলছি রেডি স্টার্ট দিস অ্যাপিল চ্যালেঞ্জেস দ্য অর্ডার ডেটেড 07/07/2016 within bracket herein after referred to as a impugned order in a special civil application number 4577 of 2016 passed by High Court of Gujarat wherein the appellant herein being Rajkot Municipal Corporation within bracket herein after referred to as a appellant corporation was directed to refund a portion of the property tax which was paid by the respondent number 02 herein named Avenue Super Smarts Limited para. Respondent number 02 has had assailed the demand raised by appellant corporation seeking payment of property tax for the assessment year within bracket herein after referred to as AY 2015-16 along with outstanding arrears of such tax dues amounting to INR 2.97 crores as a consequence to the non-fulfillment of aforesaid payment of dues by the predecessor in interest holder of the property. The premises were sealed on 21/03/2016 with prior indication to the respondent number 02 para. The High Court of Gujarat by the impugned order had allowed the special civil application moved by the respondent number 02 on the ground that the said respondent cannot be made liable for the payment of arrears of property tax which arose prior to the acquisition of ownership that is prior to 03/09/2015. The High Court deprecated the approach of the appellant corporation in challenging exorbitant amount of dues from respondent number 02 as well as the uncalled inclusion of further interest and penalty on such outstanding arrears which had already been challenged by the predecessor and had stayed by the competent court para. Considering the said circumstances, the High Court directed the appellant corporation to retain a portion of the property tax to the tune of INR 14 lakhs 85,000 relating to the relevant AY 2015-16 for which respondent number 02 had acquired ownership and possession that is from 03/09/2015 and to refund the rest of the amount of property tax along with simple interest at 6% annum per annum for the date of recovery till the actual payment of refund in compliance with the aforesaid direction refund by the High Court. The appellant corporation has already refunded such a quantum of excessive property tax to the respondent number 2 para. Aggrieved by the direction to make the refund of accrued amount of property tax dues, the appellant corporation is assailed the impugned order before this court para. It is the case of the appellant corporation that the impugned order directing the refund of property tax is contrary to the provisions of section 139 and 140 of the Gujarat Provincial Municipal Corporation Act 1949 within bracket herein after referred to as GPMC Act 1949. It is argued that a commissioner by virtue of subsection within bracket 1 of section 140 of the GPMC Act 1949 is empowered to recover such outstanding property tax dues from an occupier where a person primarily liable to pay the tax after being duly served with demand notice has failed to make the payment thereof para. Moreover, as per subsection within bracket 4 of section 140 of the GPMC Act 1949, such occupier may credit the said payment from a person who was primarily liable to discharge the liability of such dues. Thus, it was argued that from a cumulative reading of section 139 and 140 of the GPMC Act 1949, the appellant corporation was justified in recovering arrears from respondent number 2 para. Per contra, it is contended by respondent number 02 that the property in question, which is a commercial complex known as Shiblink 4 bearing city survey number 5095/1B 5095/1C within bracket P plot number 68 situated at Gondal Road, Rajkot, was acquired via deed of conveyance dated 03/09/2015 from its predecessor in interest that is respondent number 04 and 05. Respondent number 02 would be liable for the payment of property tax from the date of acquisition of ownership and not for any period before this date as affirmed by the High Court para. Respondent number 02 points out that respondent number 03, the lessee of the property prior to 03/09/2015 has challenged similar tax demands for earlier years in both civil court and the High Court, resulting in a stay on recovery actions. Consequently, it was argued that until the conclusion of adjudication of such pending appeals pertaining to the areas of any period before 03/05/2015, the appellant corporation cannot make a recovery of the said amount from respondent number 02 para. Furthermore, the appellant corporation as well as the respondent number 04 and 05 have relied on letter dated 18/01/2016, whereby it was stated that the respondent number 02 had kept INR 2 crore 50 lakh as a token of assurance for respondent numbers 04 and 05 for clearing areas of property tax para. As argued, this letter was intended to ensure that in case of failure of payment of such areas by the respondent numbers 04 and 05 within bracket predecessor owners, it shall be incumbent on the respondent number 02 within bracket subsequent owner to make the payment thereof. Addressing this argument, respondent number 02 contended that mere deposit of security amount up by respondent number 04 and 05 would not tantamount to assignment of liability for payment of tax for a period for which respondent number 02 did not have ownership. Appellant corporation cannot be allowed to ascribe obligation upon respondent number 02 to seek a remedy of refund from respondent number 04 and 05 para. Having heard the senior counsel for the appellant corporation as well as the respondents, it is imperative to decipher the undisputed facts along with the applicable provisions of the GPMC Act 1949 para. The relevant factual backdrop leading to the present impugned order commenced from the point where the original owner of the said property, namely Messrs Platinum Associates within bracket hereinafter referred to as original owner, entered into a lease agreement dated 01/12/2007 with respondent number 03 herein, namely Reliance Communications Limited, for an open space. Subsequently, the original owner sold the said property to Prabha Kantilal and Jyoti Rakesh Gandhi within bracket respondent number 04 and 05 respectively by the conveyance dated 05/12/2007. It needs mention here that respondent number 03 continued to occupy the premises thereupon respondent number 02 purchased the said property from respondent numbers 04 and 05 through a deed of conveyance dated 03/09/2015 para. Appellant corporation had raised several demand notices for payment of outstanding property tax on the premises starting from the year 2008. A notice dated 29/07/2010 was issued by the appellant corporation calling upon the respondent number 03 being in possession of the said property to pay outstanding areas of property tax along with penalty and other charges to the tune of INR 1.33 crores for the period commencing from 01/06/2008 para. The said demand was assailed by respondent number 03 by filing municipal appeal number 19 of 2010 before the civil court Rajkot, wherein respondent number 03 deposited 75% of the bill amount in court. Thereafter, for AY 2011-12 demand notice was issued of the respondent number 03 seeking payment of property tax for the said AY as well as the areas thereof, which was also challenged by the respondent number 03 before civil court in municipal appeal number 1639 of 2011. Where again 75% of the bill amount was deposited. It is pertinent to note that both these appeals are pending before the civil court with the stay on the deposit of the remaining 25% bill amounts continues para. Similar where the demands for the AYs 2012-13 and 2013-14 which were challenged before the High Court in special civil application number 3074 of 2014 on the ground of retrospectively charging of the areas of property tax by the appellant corporation. The said application was disposed of by the order dated 04/04/2014 with a direction to the appellant corporation to serve a copy of the demand notices to the respondent number 03 in view of the uncertainty surrounding the receipt of such a notice para. Further, The appellant corporation was directed to consider the objection to be raised by respondent number 03 before issuing fresh bills. The appellant corporation, consequent to the above order, proceeded to issue another demand notice for the AY 2014-15 upon respondent number 03 seeking payment of property tax inclusive of earlier arrears to the tune of INR 2.51 crore. Para. Respondent number 03 then initiated a challenge against the said demand notices issued for the AYs 2012-13, 2013-14 and 2014-15 before High Court in special civil application number 3600 of 2015, wherein the High Court by its order dated 07/07/2016 directed a stay on the further recovery subject to payment of INR 60 crore as an interim measure which would operate pending the appeal challenging the said recovery for the aforesaid 3 AYs. It was clarified that the said direction for stay would automatically vacate in the event of non-filing of an appeal assailing the demand for the said AYs. Para. The present dispute arises from demand notice dated 11/03/2016, which was issued by the appellant corporation to respondent number 02 seeking not only the payment of property tax for the AY 2015-16 but also the outstanding dues amounting to INR 2.97 crore. It was also mentioned therein that on failure to discharge the payment of the said liability, the said property would be sealed. Para. Because of non-discharge of the demand as raised, the property in question, which was now under the ownership and possession of respondent number 02 with effect from 03/09/2015, was sealed on 21/03/2016 with prior indication by the affixation of public notice on the said property. Furthermore, a final notice dated 20/02/2016 was issued by the appellant corporation for attachment of the said property and for issuance of warrant of sale owing to failure of payment of the said outstanding arrears along with penalties and charges within 5 days from the date of such notice. Para. It is pursuant thereto that the respondent number 02 proceeded to deposit the outstanding dues qua the said property and challenge the aforesaid action of the appellant corporation before High Court on the grounds as recorded above. Para. It is evident from the aforementioned factual strata that the respondent number 02 would fall in the category of section 139 within bracket 1 within bracket small b or within bracket small III of GPMC Act 1949, being the owner of the said property. It is clear and undisputed that the respondent number 02 had purchased the said property from respondent numbers 4 and 5. Therefore, till 03/09/2015, the person primarily liable to make a payment from a co-joint reading of section 139 and 140 of the GPMC Act 1949 was the lessor of the said property, that is respondent numbers 04 and 05. The liability prior to 03/09/2015 thus cannot be foisted upon respondent number 02. Para. The High Court was thus correct in observing that respondent number 02 was liable to pay property tax from the date of acquisition of ownership. Further, the High Court had been conscious enough while directing deduction of the liability of the tax from respondent number 02 for the relevant period that is subsequent to the date of purchase, being 03/09/2015, prior to making refund of the remaining amount along with interest. It may be added here that this impugned order has been duly computed with by the appellant corporation and the amount has already been refunded as evidenced from communication dated 25/07/2016 and later dated 28/07/2016. Para. Although considering the above factual matrix, the challenge against the direction for refund in the impugned order in light of the provision of section 140 of the GPMC Act 1949 has become a mere mere academic exercise, yet we may proceed to look at it from another perspective here. Respondent number 03, the lessee of the property acknowledged the demands raised by the appellant corporation for the period prior to 03/09/2015 and even challenged the same in the statutory appeals. The said challenge pertaining to the demands for previous 3A-wise, that is from 2012 to 13 to 2014 to 15, were disposed of via an interim stay order upon deposition of a certain amount para. It is opposite to note herein that the appellant corporation has neither challenged the said stay order dated 07/07/2016 passed in a special civil application number 3600 of 2015, nor has contested before us that the respondent number 02 has not filed statutory appeals as directed therein. So the contention of the respondent number 02 that pending such adjudication of appeals, the appellant corporation cannot challenge the correctness of directions of the High Court for refund of the amounts as deposited by respondent number 02 cannot be faulted with para. Another aspect which cannot be lost sight of is that 75% of due amounts as per the bills raised by the appellant corporation for the AYs 2010-11 and 2011-12 stand deposited before Civil Court Rajkot in Municipal Appeal numbers 90 of 2010 and 1639 of 2011, securing a major portion of the liability subject to outcome of the appeals, where the appellant corporation being a party thereto and is contesting cannot be permitted to take double benefit para. Moreover, in case the said appeals get dismissed, the deposited amount would eventually be paid to the appellant corporation. This would result in a situation where the appellant corporation would have a sum deposited in its favor equivalent to over and above the actual outstanding amount para. Thence, to obviate such double payment in favor of the appellant corporation and causing disruption in the pending litigation against the demands accrued prior to 03/09/2015, we are of the opinion that the order directing refund by the High Court stands justified considering the peculiarity of the aforesaid facts and circumstances. In light of the aforesaid discussion, we do not find any ground to interfere with the impugned order dated 07/07/2016 passed by the High Court. The appeal is therefore dismissed para. Pending applications, if any, also stand disposed of. There will be no order as to cost. Stop. Thank you.